impact on many in the community. This briefing is intended to provide the community with factual information about this incident. As your new elected district attorney, reviewing officer-involved shootings and in-custody deaths is one of the most serious parts of the job. I recognize the incredible responsibility that places in me and that we have to conduct a thorough and objective review of the facts and the law in order to deliver an equal and fair justice, one where no one is above the law and law enforcement is held accountable when appropriate. As we've done in the past, we will charge a police officer or a deputy sheriff when the facts and evidence prove they committed a crime. I met this morning with Mr. Earl McNeil's family. That was a tough meeting. I gave them my condolences for their loss. They lost a loved one, and that is just a terrible, terrible feeling. I told them that the purpose of the meeting was to be able to share with them the information, to let them view the videotape, and to also tell them what I'm about to tell you. I felt that they deserved to learn the information first, and that's what I did. Great family, and it was. I hope that at least in knowing more facts, that they're able to feel that they at least have the information. In addition to making our analysis public, at the conclusion of this media briefing, we'll be releasing the following. This will be the first time that a video of an in-custody death is released. 2 hours and 25 minutes were captured on videotape or surveillance tape. It happens that almost every minute of the interaction with Mr. McNeil was captured either by body-worn camera evidence or by surveillance evidence. Because in-custody deaths are different than officer-involved shootings, where you can select a moment and time that is relevant to the criminal review, in-custody deaths like this one involve the entirety of the incident. I've determined to release the whole 2 hour and 25 minute video. For the purposes of this media briefing, we have condensed that nearly 2.5 hours to a representative 55-minute version, which will be shared with you during this briefing. But you will get on a flash drive at the end the 2 hours and 25 minutes. You'll also get the letter outlining the district attorney's review and legal conclusions, which was provided to National City Police Department and the Sheriff's Department yesterday. Broadcast outlets that are live streaming this press briefing are advised that these videos contain content that is disturbing, it has strong language, it's heart-wrenching at times, and it's not appropriate for children. This video is evidence. It's exempt under the California Public Records Act. Our decision to release it doesn't otherwise waive that privilege. We don't plan to release any additional evidence from the investigatory materials at this time, and will continue to claim the privileges under the law. As you're aware, I want to talk to you a little bit about our body-worn camera protocol. As you're aware, the DA's office has been releasing videos of officer-involved shootings for more than 2 years now, as part of the protocol that was signed by the Police Chiefs and Sheriff's Association. During that time, the parameters for release of videos of in-custody deaths that are referred for evaluation of criminal liability were not part of the protocol. I believe that San Diego County was the first to have a protocol with regard to officer-involved shootings in our state. I do believe that sharing as much information with the public, and including body-worn camera evidence, is important in order to build trust and provide information that makes it clear to the public that there is open and accountable government. While the protocol says the release is only for the video that determined the decision today, I felt that there was many parts of the video that were relevant. Of course, it must be balanced with due process and privacy rights. That's why we've been working for months on an effort to amend the protocol. This review is the first to fall under this expanded protocol. The police chiefs and sheriffs have all agreed that other incidents that result in death that are referred to the DA's Office for Criminal Liability, like certain in-custody deaths, will be subject to the new protocol. The protocol has not been formally signed, but it has been approved, and therefore today I am operating as if it is in effect. For the past months and weeks, we've been working to amend the protocol, and it's now updated. Our goal is to have a video release policy that serves public interest and preserves individual rights. This latest change really reflects the community's ongoing interest in seeing this type of video, as well as law enforcement's desire to make the evidence public and to provide a window into how these types of serious cases unfold. The community will now be able to weigh the video alongside other evidence for themselves. As body-worn video has been released in our community over the past 2 years, the public has begun to see the gritty and often dangerous reality that is involved in responding to duty calls. They've also seen on the video citizens captured in their toughest moments. A lot of folks with mental illness and with addiction, and oftentimes mental illness with addiction combined together, providing a very, very dangerous formula. Presented out of context, of course, a video clip can lead to inaccurate and inflammatory narratives about an incident, but I'm going to trust that the media and that people will view it in context. Understanding how these incidents occurred and the basis for the decision-making process, I think, is a cornerstone for democracy. Let me briefly discuss the legal review standard before we play the 55-minute video for you. The purpose of the DA's review of in-custody deaths is to determine whether criminal charges should be filed. That's the decision that I'm going to be releasing today. In other words, was a crime committed? We review all the evidence to determine what the facts are, what we can prove beyond a reasonable doubt. We don't review department policies, training, or discipline. Later on, I'm going to talk to you a little bit about that part, because in addition to making the decision today as the district attorney determining criminal liability, I do have a duty as a public safety leader to continuously look at training and at crisis interventions and look at ways to make the public safer. Today, though, we don't review civil liability at all. Those are not considerations outlined by the law for purposes of this review. I want to provide you a little overview of the facts. I think it will help you track the video a little bit better. Mr. Earl McNeil was 40 years old at the time of this incident. The information contained in court and other records shows that he suffered from schizophrenia and had been referred in the past to both mental health and substance abuse treatment. The drug that seems to be most common with him is methamphetamine and amphetamine abuse, and it was present in very high amounts in this particular incident. He had a long history of contact with law enforcement. Some of it included violent behavior, including violent conduct, recent possession of a loaded firearm, having a baton, felony domestic violence, and other incidents. A recent 2017 DUI incident that involved methamphetamine was informative as to the state of his dental structure and other things as compared to this particular incident, as I wanted to be sure that we are checking for any type of excessive force, any type of teeth that are knocked out, or anything like that. So we resorted to that most recent case from September of 2017 to do so. But in addition to this history to Mr. McNeil, Mr. McNeil was very courageous. He drew a line, even as a gang member, against gang members that took out 2 wonderful women in his community and shot a little boy 6 times. He decided to have the courage to stand up to that, risking his own life. This incident began on May 26, 2018 at 5:28 a.m. Mr. McNeil contacted National City Police using an emergency telephone near the front door of the police department. Mr. McNeil asked for someone to come out, front saying he wanted to turn himself in on a warrant. He said he wanted to kill an expletive and said he wanted to kill Jesus. He said he was high. He said he didn't know his name. He hung up the phone. He called back a few moments later, identified himself as Earl McNeil. He picked up the phone a total of 4 times, but only spoke twice. As you'll see, his calls and activity in front of the police station were recorded by surveillance cameras. For a more complete picture of this interaction, we've married the surveillance footage with the audio from the phone calls. Officers were dispatched. They were told that Mr. McNeil claimed he had a warrant for his arrest, had said he wanted to kill people, appeared very agitated, and had said he was high. You will hear the dispatch call to understand what the officers had in mind. 2 officers initially contacted Mr. McNeil at the front of the station and were soon joined by additional officers. He agreed to let the police check him. They detained Mr. McNeil for possibly being under the influence of a controlled substance and placed him in handcuffs. Mr. McNeil became agitated. He began yelling and pulling away. When the officers began to pat him down for a search for weapons, he lunged towards the railing that runs across the landing in front of the station, with rocks and hardscape about 6 feet down on the other side of the railing. 3 additional officers arrived and assisted, holding Mr. McNeil down on the ground for his safety and the safety of officers. As you'll hear on the video, Mr. McNeil made various statements that were concerning to officers. In addition to the statements he made on the phone, he continued to say that he's going to kill somebody, that he's a pimp, that he has a lot of girls in room 232, he's going to effing kill somebody. And when officers tried to talk to him and call him by name Earl, he said, "Who's Earl?" Police found a baggie containing methamphetamine in Mr. McNeil's pants pocket weighing 1.8 grams and a knife in the other pants pocket. Mr. McNeil continued to resist with surprising strength, but not surprising with folks with use of methamphetamine and potentially the beginning of a delirium, requiring several officers to hold him down, so they decided to use what's called a wrap. There's a photo of a wrap in use. I think you have it on your screen. The wrap is a safety restraint designed to de-escalate a situation, stop physical conflict, and prevent potential injury to the subject and to officers. It alleviates officers from having to use more force to bring a person under control. It's also designated to prevent pressure on the chest. For a brief period, Mr. McNeil stopped yelling and was relatively calm. While the wrap was being put on, Mr. McNeil began to spit at the officers. The officers placed a mesh protective sock over his head to prevent him from spitting on them. It's known as a spit sock and is commonly used by law enforcement agencies. Spit socks that are designed to prevent the transfer of communicable disease while at the same time allow the wearer to breathe. This is a photo of the spit sock that is used by National City Police. As you'll see in the video, Mr. McNeil continued to spit at the officers and then began to grind his front teeth on the cement, which the officers tried to prevent by lifting his head off the cement. Mr. McNeil injured his mouth while grinding it on the cement and began to bleed slightly through that grinding motion. You'll notice a little bit of blood on the sock after that grinding motion. The officers tried to hold his head so he wouldn't injure himself further, and also to make sure he doesn't spit on them. Mr. McNeil continued to yell, saying he couldn't breathe and that the officers were killing him. Then he would yell that he was alive. On these videos, you will hear Mr. McNeil repeatedly say he can't breathe. You'll also hear him say that he's having a seizure. You'll also hear and see officers assess his condition, respond to those statements, and monitor his well-being. You'll hear officers asking him his name and him responding, and then officers saying, if you're able to talk, then you can breathe. You'll also hear later from the coroner that he confirmed that he's not aware of any incident where somebody can be talking, because he reviewed the video in the same way while not being able to breathe. Also that he's not aware of a condition where you could actually be in a seizure and be telling officers you're having a seizure. He did not believe from the videos that that Mr. McNeil was having a seizure. At one point, Mr. McNeil spat blood on an officer. Mr. McNeil continued to make statements about having a seizure. Officers could see that Mr. McNeil appeared to them to be pretending to have a seizure as opposed to reality. Again, this assessment by police is supported by the medical examiner's opinion that Mr. McNeil was not in reality having a seizure. Once Mr. McNeil was secured in the wrap, he was placed on his side briefly, during which time he purposefully hit his head, and you'll be able to see this on the pavement, before officers could get him back upright. He continued to spit both blood and saliva at the officers through the mesh spit sock, telling officers that he's spitting on them. Officers carried Mr. McNeil to a patrol SUV and placed him in the back. There's about 14 times that Mr. McNeil specifically says throughout that he's spitting on the officers, which is relevant to determine whether, for me, whether this was a gag reflex from not being able to breathe or a purposeful spitting. So you'll notice most of the times that he talks about purposefully spitting on the officers are heard on tape. A couple are not heard because they're in the sheriff's jail where is a surveillance video. 15 minutes had elapsed from the officer's first contact with Mr. McNeil until he was secured in the police vehicle. Next, officers drove Mr. McNeil to a temporary holding facility at the National City Police Department. Due to his erratic behavior, he remained inside the vehicle with the window partially down and the air conditioning on for 1 hour and 14 minutes, while an officer completed paperwork. During this time, Mr. McNeil was continuously monitored. Included in the video we're providing the media today is surveillance video during the entire 1 hour and 14 minutes. He's in the back of the police vehicle. The video is blurred for security concerns, but is otherwise unedited. It shows that while officers monitored Mr. McNeil, they had no physical contact with him during this time, just a visual observation. Due to his behavior, it was deemed necessary to have 2 officers drive Mr. McNeil to the San Diego County Central Jail. At the beginning of the transport, one of the officers puts his body-worn camera next to the plexiglass partition that separates the back seat from the officers. The camera during this 8-minute ride to the jail in the rear was able to record the entire transport. As you'll see and hear on that video, during the 8-minute ride, Mr. McNeil struck his head several times against the plexiglass partition. Later, you will learn that the coroner observed that the superficial injuries to his face were consistent with hitting his head against the pavement and hitting his head against the plexiglass. There was no blunt force trauma to him. The police SUV arrived at the county jail's intake, and officers left the SUV. During that time, Mr. McNeil continued to speak into the body-worn camera. 2 fixed video cameras in the jail intake area recorded every minute Mr. McNeil was at that location, although they do not record audio. The only audio from the intake area from the jail was an officer's body-worn camera during periods when he was engaged. You will hear on the video that Mr. McNeil again said he couldn't breathe, but he continued to carry on a conversation, at times speaking into the camera as if to another person. Mr. McNeil showed no visible signs of medical distress. He was able to speak freely at that point in time and without difficulty. But you will see that for yourself. As soon as the side door of the SUV was opened to remove him from the patrol unit, Mr. McNeil began to shout help repeatedly. In the intake area at the jail, Mr. McNeil was removed from the back of the SUV with the assistance of several jail deputies and placed on a gurney so a jail nurse could evaluate him. He continued to spit at the deputies through the sock. The sheriff's deputies placed a second spit sock made entirely of mesh over the first sock that was placed by National City Police Department. This is a photo of that sheriff-issued spit sock. The deputies released the chest-to-ankle strap of the wrap so Mr. McNeil could lie flat on his stomach on the gurney while the jail nurse examined him. In the video, when you see the video, look for a bright blue scrub uniform, which looks different than the other uniforms, and that's the jail nurse. It's a male jail nurse. Mr. McNeil remained agitated throughout the medical evaluation. He responded to the nurse's questions, but also continued to yell and scream. He told the nurse he was suicidal and needed to see a doctor. The jail nurse noted the potential beginning signs of what's known as an excited delirium. Excited delirium is a condition that presents as agitation, delirium, and sweating. It may include attempts at violence, unexpected strength, and very high body temperature. It's fairly common with the use of methamphetamine and especially long-term drug use. The nurse noted that Mr. McNeil was sweating profusely. He had an elevated temperature of 100 degrees and a rapid pulse of 120 beats. At that point, the nurse did not believe Mr. McNeil was experiencing an overdose because he was still alert and oriented. Mr. McNeil continued to move back and forth, pulling on his wrists against the handcuffs to the point where the cuffs cut into his skin. He stated he was homicidal and suicidal. At the end of the evaluation, Mr. McNeil was taken out of the prone position and the chest strap portion of the wrap was reattached, resulting in him being repositioned into a seated position. The jail nurse, in consultation with sheriff's staff, declined to admit Mr. McNeil to jail and instead referred him for a medical and psychiatric evaluation. The call for paramedics was received at 7:28 a.m., approximately 15 minutes after Mr. McNeil had arrived at the jail intake. As you'll see in the video, deputies were surrounding the gurney to stop Mr. McNeil from falling off as he was still moving around. They were in close proximity to Mr. McNeil in order to prevent him from falling, and with that close proximity, he continued to spit on them. Once the body-worn camera inside the patrol vehicle was turned off, there is no audio, but video continues to capture. Mr. McNeil continued to spit through the two hoods, which had become saturated with bodily fluids. One of the deputies was struck in the face by fluids penetrating the mesh. Mr. McNeil told the deputies, "I got you, F-U-C-K-E-R. I spit blood on you. You're going to get AIDS now." The deputy that was struck walked away. You'll see that on video, to wash off. Another deputy pulled the collar of Mr. McNeil's T-shirt up and held it up to shield the deputies from further contact with his body fluids. Mr. McNeil bit the top of the T-shirt that was being held up and therefore was still able to blow and spit. You'll be able to see, if you look closely on the video, the white T-shirt being held up, but you have to really look for it on the video. The shirt did not completely cover Mr. McNeil's mouth and nose. He continued to blow bodily fluids through the spit mask by expelling air from his nose. San Diego Fire Department paramedics arrived within 6 minutes after they were called. Approximately 30 seconds before the paramedics arrived, Mr. McNeil quieted down, but continued to make grunting sounds and move around. When paramedics arrived, the spit socks were removed to check for vital signs. The first paramedic to examine Mr. McNeil noted he was alert to painful stimuli, was breathing, and had a pulse. The paramedic put back one spit sock on Mr. McNeil because they were told by officers that he had been spitting blood on them. There were no signs of debris in or around Mr. McNeil's mouth. Mr. McNeil continued making noises and moving his head from side to side as he was transferred to the paramedic gurney. As he was lifted into the ambulance, Mr. McNeil became more lethargic. Once inside the ambulance, Mr. McNeil was observed breathing but had a weak pulse. Paramedics continued to monitor his condition for about 6 minutes, a little bit less. With the ambulance there, it was determined that Mr. McNeil had stopped breathing inside the paramedic truck and his heart had stopped. As you'll see on the video, he was removed from the ambulance immediately, taken out of the wrap, and CPR was started. Once they placed him on the ground in order to get a better CPR process. Once a pulse was detected, Mr. McNeil was moved back into the ambulance and taken to UCSD Medical Center. Mr. McNeil died 16 days later on June 11th at UCSD Hospital, and an autopsy was conducted. The cause of death was determined to be hypoxic ischemic encephalopathy, which is brain damage, essentially due to lack of oxygen. And the coroner said that it was due to resuscitated cardiorespiratory arrest and also due to methamphetamine toxicity, agitation, and respiratory compromise. And the coroner also determined, since there were human hands or hands of another involved, that the manner of death was homicide, which the coroner explains is a different definition than the legal definition for murder. Their definition is the homicide label is used for anything that involves human hands in a situation like this, like an in-custody death. There are other reports that you can refer to where similar situations with methamphetamine, the coroner makes those determinations. Toxicology results show Mr. McNeil had high levels of methamphetamine and amphetamine. The sample was taken at 8 a.m. on 5/26 when he was in the hospital. To be precise, he had 0.61 milligrams of methamphetamine and 0.04 milligrams of amphetamine. It's important to note that in San Diego County, 368 meth-related deaths happened last year. And many of those involve the symptomology of cardiac arrest and similar situation. These sad statistics that the medical examiner is well aware of is why he put in his report that the methamphetamine alone was sufficient to kill him. The medical examiner who performed the autopsy was interviewed. He stated that the concentration of methamphetamine in Mr. McNeil's blood alone could have caused the heart attack. The medical examiner was unable to determine whether the cardiac arrest caused the respiratory arrest or vice versa. He also said the superficial abrasions and contusions to Mr. McNeil's forehead and cheekbones were consistent with him struggling with officers on the concrete, hitting his head against the concrete, and hitting his head against the plexiglass divider in the police SUV. After reviewing the videos, he also said there was not evidence that Mr. McNeil suffered from a seizure while he was in custody. Also, the coroner confirmed that where Mr. McNeil is saying, "I can't breathe," in those times, not the time where there's 30 seconds when he slows down and stops speaking, that Mr. McNeil's ability to speak and yell continuously through the entire time he was in custody, and the majority of the time he was in jail, suggested he wasn't experiencing much respiratory compromise at that time and was indeed breathing. During the 2 hours and 26 minutes it took for this incident to unfold, Mr. McNeil interacted directly or indirectly with more than 25 individuals. 7 National City Police officers, 1 National City Police dispatcher, 8 San Diego County Sheriff's deputies, and several San Diego Fire Department paramedics, along with 1 San Diego County jail nurse. The various body-worn camera and surveillance videos have been edited together in chronological order. Again, for the purpose of this media briefing, the collapse timeline you're about to see runs 55 minutes and contains subtitles and other clarifying text. You're going to see captured in 4 locations. First, the first video shows Mr. McNeil outside the National City Police Department making the 911 calls, the response by the National City Police officers, and his arrest. This takes about 19 minutes, from 5:28 to 5:47 a.m. The next video will show the patrol unit sitting in the National City Police Department's Sally Port. You can't see Mr. McNeil in the patrol unit, but you'll see officers monitoring him. That's from 5:47 to 7:04. You will have that on your flash drive, but here you'll only see a moment of it because it repeats. The same view will be the same. For the purpose of this briefing, you'll see a small clip of that. The next video lasts about 8 minutes, shows Mr. McNeil in the back of the patrol car being transported to the San Diego County Jail by the National City Police officers. That's from 7:04 a.m. to about 7:13 a.m. The final video shows Mr. McNeil when he was taken out of the patrol unit at the jail and is being evaluated by the nurse, and how the deputies and officers acted while Mr. McNeil was in the jail. That timeline is 7:13 to 7:53 a.m. when the paramedics leave with him to UCSD Hospital. He arrives around 7:13, and the nurse is there on hand to check him at 7:18 till 7:22. And paramedics then are called, and the decision is made to call paramedics at 7:26 a.m. Okay.
This is a 911 call.
Conversation recorded on May 26, 2018 at 5:27 on channel 2.
Nashville City Police, 770.
Yes. Can you come out front? I'm going to turn myself in. I got a warrant. I'm going to kill this motherfucker. I'm going to kill Jesus.
What's your name?
I don't know. I'm high.
You don't know your name?
The 331 down on the cover. You can make it 1019 to the front of the PD. Should be a BM and a dark jacket, red pants. Same thing as a warrant, wants to kill people. Right. Keeps picking up the phone and calling and then hanging up. Appears to be very agitated. Stated that he was high. It's the front of the PD.
Oh, yeah, bro.
31 down from the Argo at 8 over the
Sit down right there. Sit down real quick. Bank card, do you have any weapons on you? spit on my leg. Hold on.
Okay, you're intending to get the broad gate.
She not. Where they gonna take you? To CMH Hospital.
Confirm.
CMH Hospital. To see the doctor. CMH Hospital. To see the doctor. I'ma kill myself. Yeah. National City Police Department. Taking Earl McNeil to CMH
And 133 the chief, huh?
to get evaluated by the motherfucking doctor because he said he wanna kill himself. You wanna kill yourself?
25 also. There's no answer to the apartment, the door's open.
That's what you're saying.
Well, we'll make an
I'm
announcement.
gonna kill myself. I don't wanna go to CMH like y'all said, fool. Fuck that. I'm gonna kill myself.
Emergency traffic for an open door.
National City Police Department. They kidnapped Earl McNeil. From the roadway in, hotel, with the mafia. They was in AMPM. Check the camera. They got the camera in the window. Earl McNeil, did you go into AMPM? Why? National City Police. Earl McNeil, you got a warrant.
133 just one.
You going to jail, Earl. You have a warrant for a baby. East 8th Street. Yeah, East 8th Street. You have a whole warrant, Earl McNeil. You're going to jail. San Diego County Jail. You're going to San Diego watch him on the camera. Hey, sir. Look at the blood. I can't breathe. It's too tight. I can't breathe. They fucking trying to kill me. See how tight this is? Read my lips. National City Police got me in the Central County Jail, downtown Central. You know? They won't let me breathe. It's too tight. Look at me. You see? National City Police. See, I told you. They working for a month, you can check me out. I was at the roadway in 34466-026. What's wrong, bro? I'm on psych medications, man. I haven't had my psych medication. I need to talk to a doctor. Why? Do you need to go to CMH? I need the psych eval, man. I got mental problems. I have tried to kill myself. You have? Okay, bro. We picked you up because you had a warrant for a baby. Yeah. Yes, you had a warrant? You had a fucking warrant? Yes. Why did you run? What? Oh my God, bro. Earl McNeil. Look, they said that it's a wrap. They said they're gonna take me in and they're not gonna let me talk to the nurse. They said they're not gonna let me talk to the nurse. Why?
Negative voicemail and recall. Will you try one more time?
Earl McNeil, who was in the roadway in, and you know why they want to kill me? I tell you why. This is the truth, people. This is the truth. Here comes the sheriff from Central Jail, coming up out of the intakes with gloves. What's wrong, bro? I need to see the psych.
225 Street to
I need to talk to the psych doctor. I'm not feeling good, man. Why you not feeling good? Because, man, I need to talk to the doctor. You need to talk to the doctor? What kind of doctor? Medical. The nurse. The paramedics. They gonna kill you, Earl. I know. They're not gonna let you talk. I need the paramedics. I need the fucking paramedics. Yeah, let's go from this side. I'll pull from this. No. I don't have a booking number. My name Earl McNeil. Ah! Yeah! Help! 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 They gonna drag me out! Look! I got you! Help! Look at it! Help! 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 Help!
Alright. Unit 20, GA, any recall? Camera. One 34 times, close for plate. Over. 8 Charles, Ida Victor 0, 3 times. 29 current, 08 Volkswagen City. Pencil.
Thank you for your patience with this. We wanted to make sure it represents all four portions of the event accurately. As you can see, it's hard to cut things out because they all are part of the whole incident. So we're getting to the end. I'm going to just quickly go over the law with you and take you to my conclusion. In reviewing potential criminal liability of the officers involved and the deputies, it largely becomes a question of one's intent. To be charged with murder or voluntary manslaughter, the people must prove an intentional act. There's no evidence that the officers intended to kill Mr. McNeil. Involuntary manslaughter is another charge that we considered. It requires that someone commit an act with criminal negligence. Criminal negligence involves more than ordinary carelessness, inattention, or mistake of judgment. It's different than the civil standard. It's higher. In other words, criminal negligence occurs when a person acts so different from the way an ordinarily careful person would act in the same situation that his act amounts to a disregard for human life or indifference to the consequences of the act. In this case, you can see that all of the officers and deputies acted in much the same manner. For any criminal liability to exist, the acts of the officers and deputies, be they intentional or negligent, must be a substantial cause of Mr. McNeil's death. Mr. McNeil died of fatal brain damage due to the lack of oxygen. That lack of oxygen was due to cardiorespiratory arrest and subsequent resuscitation. According to the medical examiner, Mr. McNeil's medical condition could be due to one or more of multiple causes. Methamphetamine toxicity is the most substantial cause and could by itself have caused his death, according to the medical examiner. Also, methamphetamine toxicity likely contributed to his level of agitation and his drive to continually struggle against the officers, the deputies, the rap, and his handcuffs. The increased need for oxygen caused by that level of exertion can similarly cause cardiorespiratory arrest alone, according to the coroner. Any potential contributing cause, such as the use of the rap intended to reduce force by officers and 2 spit socks intended to shield officers from potentially deadly transmitted diseases while allowing persons to breathe, and a lifted T-shirt to further shield after blood got on an officer cannot be legally viewed as making the officers and deputies criminally liable. During Mr. McNeil's time at the jail, a medically trained nurse did not notice any distress beyond the elevated pulse and respiration that were consistent with his level of agitation and exertion. Nor did trained paramedics initially notice any exigent problems with Mr. McNeil. In fact, Mr. McNeil was under the direct care of medical professionals when he suddenly stopped breathing. You could see from the video that they systematically loaded him onto the paramedic, the ambulance, and with care but without rush, and then they took him out of that when his heart stopped. So his heart stopped breathing while in the paramedic's care. The video evidence and extensive investigation supports the legal conclusion that actions of the officers and deputies are not a substantial factor causing his death beyond a reasonable doubt. They were not intentionally intended to cause his death and were not a disregard for human life or indifference to the consequence of the act. While the officers believed he was under the influence of a controlled substance, the life-threatening nature of his intoxication was not immediately clear. In fact, as you can see, he continued to speak and talk and interact until we're told about 30 seconds before the ambulance arrived is when he started to still grunt, but he wasn't visibly speaking and reacting. Even to the trained nurse who examined him initially and the paramedics who responded, the seriousness of his condition was not readily apparent. We do know that especially with meth toxicity, things change in a moment from activity to death. Considering all the circumstances established by the evidence, it cannot be proved beyond a reasonable doubt that Mr. McNeil's death was the direct, natural, and probable consequence of actions of either looking at the entirety of the incident, there is not a single act of excessive force use. So part of the examination of the death causes, it's what contributed to the death. But we also looked at excessive force. We wanted to see if at any time, even if it didn't lead to the death, officers acted in a way that showed excessive force. Based on the evidence and the evidence that you reviewed and will have in your possession, at no time, and we've looked at this repeatedly, did any officer hit, punch, kick, use a baton, or any other weapon on Mr. McNeil. Even as he was spitting on the officers, you see the officer, if you look again at the video, walk away from him, or even make light of, earlier in the video, of the spitting. Based upon the review of the facts and circumstances surrounding Mr. McNeil's death, the National City Police Department officers and the San Diego County Sheriff's deputies involved in his detention are not criminally liable for murder or any lesser or related criminal charge to murder. They bear no criminal liability under California law for their actions. I'm thinking that you're going to ask me about the informant status, so I'm going to try to answer it for everybody. As been reported widely in the media, Mr. McNeil worked with law enforcement and with the DA's office on a major murder case. This murder case took place New Year's Eve 2002, where 2 women were killed going to midnight service, church service, with a 6-year-old and a 2-year-old. The 2 women were murdered with an AK-47. The boy was shot 6 times, shielding the 2-year-old. Cooperating witnesses are a common, and this case wasn't solved and was put to trial in 2011. Mr. McNeil was a witness in the case. Cooperating witnesses are a common, if not very publicly discussed aspect of police work. When they are part of a criminal case, prosecutors work with them under very strict legal rules. However, Mr. McNeil was not a mercenary type informant, meaning he didn't cooperate and testify in exchange for leniency for his own criminal conduct. Even though he had ties to the gang, he was not a part of this murder. So he was not an informant in the sense of being offered a deal as part of this murder to testify against others. Rather, he was a witness and provided testimony in the Dr. J's liquor store shooting case in southeast San Diego, in which 2 women were killed and the 7-year-old was seriously injured by a notorious gang member who terrorized the community. The judge, defense, and jury were well aware of his mental health issues, which were addressed during the trial. His corroborated testimony about a relevant piece of evidence, the weapon, helped the people, along with other evidence, to hold murderers accountable in their crimes. Again, Mr. McNeil's testimony was not in exchange for leniency or even money, although it's been reported that he received money. He received nothing in exchange for his testimony. What he received is what is common in this civilized state. When witnesses put their life on the line, there is a state fund that pays for witness protection so that they can be relocated and can not suffer the consequences of telling on a gang. He did it, as he said, to do the right thing. That's the part of Mr. McNeil that I shared with you that makes this extra tragic. Mr. McNeil was not a witness in any other criminal trials other than where he was a victim of a gang shooting himself. And he provided information on 2 other cases but didn't receive any benefits and was not compensated. Like I said, Mr. McNeil did receive reimbursements associated with the cost of witness protection. including expenses and essentials, costs associated with his and his family's relocation out of San Diego for his personal safety, which is typical and more than reasonable. The state of California reimburses costs of relocation, living expenses for courageous witnesses and informants that put their life on the line to prevent violence. This is what makes this death a terribly sad event. Mr. McNeil had his own substantial criminal record, including violence and possession of guns and drugs and other things up to recently in 2017. However, there was a part of Mr. McNeil that wanted to help his community and to be a good man and to do the right thing. There's been questions about the relationship with DA investigator with our office. It's true that over the course of the last 9 years, Mr. McNeil built a relationship with the investigator from our office that worked on the Dr. J murder case. The district attorney investigator became a stable influence in Mr. McNeil's life. He tried to be a support person to Mr. McNeil as much as he could. And even after the trial was over, he didn't discard him, helping Mr. McNeil obtain his medicines, calming Mr. McNeil down when he threatened suicide or had suicidal thoughts, which was fairly common. It's been suggested that because of this officer's prior relationship with Mr. McNeil, we should have recused ourselves from the review of this death. In an abundance of caution, we reached out to the California Attorney General's office for their opinion. The AG's office found no reason for the DA to recuse ourselves from this case. Clearly, there was no bias against Mr. McNeil. We live in challenging times in this country. There is a well-established and ugly history of people of color being abused, and sometimes by law enforcement. That puts an extra burden on the prosecution to make sure that under this pressure and scrutiny that we share as much information, that we inform the public, that we are very transparent with this great responsibility. Now more than ever, the prosecutors are held to a standard of making sure that not only are they objective, but that we show that through conduct and action. We have a duty to get to the truth based on the facts, evidence, and the law. This is why an experienced team at the DA's office has worked diligently since August 9th of 2018 when we received the case, and literally around the clock, leaving no stone unturned in examining every piece of evidence and not taking anything for granted. In addition to carefully reviewing the video evidence and reports, we even looked at whether we could locate a source of Mr. McNeil's chipped tooth, because it doesn't look good in the autopsy pictures, and found a photo from an earlier arrest for being under the influence in September of 2017 that showed almost identical same chipped tooth predated the incident. We asked the coroner about the marks on Mr. McNeil's wrists that look bad, and whether they could have been caused by the officers having the cuffs too tight or doing something with the cuffs. In doing so, we learned the type of marks were consistent with Mr. McNeil pulling constantly at the metal handcuffs. We asked questions about the marks on Mr. McNeil's face and learned that none were blunt force trauma, but rather they were consistent with what the video shows: Mr. McNeil grinding on the cement, hitting his head against the ground, and his head on the plexiglass in the patrol car. In fact, the coroner referred to the way that the officers treated Mr. McNeil during the arrest in taking him down to the ground as gentle compared to what he had seen in other incidents. We questioned the response of the officers to Mr. McNeil when he was stating he can't breathe repeatedly, and these seizure claims that he made. But again, in reviewing the videotape, the medical examiner felt that it was clear neither of those incidents were going on. He was breathing and he did not experience a seizure. we will never really know what exactly, what is the point that caused the death. We know from the coroner that we have the very high methamphetamine level that the coroner puts in his report that should be public for you to have, that it is enough to have killed them. That toxicity level of 0.61 milligrams of methamphetamine with 0.04 of amphetamine, the methamphetamine active in his blood. We know that he was resisting, and you saw that over 2 hours he was agitated and continued to be agitated, which is tied to delirium. It's also tied to methamphetamine use. It could be tied to his mental health state, but that, according to the coroner, also exaggerates and aggravates his medical condition, potentially leading to that heart respiratory failure. We also know, and we can't assess what value it had, that he had 2 spit masks, and even though they're intended where people can breathe, and that he had a wrap, which is also intended for people to actually have less injury because of it, and there was a T-shirt because he was spitting. It is, again, it's unclear what value, what that translated into the formula, what it could have done. It's unknown. The only thing that we know for sure is the methamphetamine level by itself is sufficient. We don't know the other factors. We look at the video evidence and we see that he's still talking and acting, and that the most critical piece for me is that medical personnel was on hand, the nurse, to examine him, and walked away after examining him because there was nothing critical at that moment. He was being referred for his suicidal ideations, for his threats of homicide. So these are the things that we know. So at the conclusion of this case, there is no way in good faith to look at this and say that there is evidence beyond a reasonable doubt that the officers committed a criminal act that was substantial in causing his death. Thank you very much. Do you have any questions?
Was there ever a point where he asked for medical assistance and it was denied?
It's everything that you see on tape. So you see on tape that he says, "Take me to jail," and then he sometimes says, "Take me to a hospital." He says, "Take me to a doctor, take me to jail." So it's what you see on tape.
Obviously, he was acting erratically. You mentioned that it wasn't until he got into the ambulance that it appeared his condition was critical. Oftentimes, people get taken into ambulances for much less. It does not have to be critical to mean you should go to the hospital. You look like you're in a state that warrants medical care. Why was that decision by the officers not made earlier, even from their initial interactions? He seems suicidal, he seems erratic, he seems high, he seems like he's in a state where now we know his toxicity in his body from the meth was already at potentially deadly levels. Why was there no decision earlier to get medical attention?
This is the course that they took. He had 1.8 grams of methamphetamine on him. He was repeatedly saying he's going to kill someone. He mentioned that he'd killed someone. He mentioned he's a pimp and that he has girls in a hotel room. They felt, based on that totality of circumstances, they should take him to jail. It's at the jail that then a nurse evaluated him.
Is it unusual, 2 things, that he was in the police vehicle in National City for an hour and 16 minutes being monitored? At that time, is that common that you keep somebody just in a car for that long? And is it standard procedure or prohibited at all to use 2 spit cells? Is there anything in the protocols of the use of those that would militate against it?
And I don't know, Greg, if it's common to keep somebody for an hour and 15 minutes. Just from my general almost 3 decades in in this field. I've seen cases where that's happened, where officers are filling out reports. I don't know if there is a specific protocol on it, and I have not seen any specific language prohibiting to spit socks.
Deputy Attorney Stephan, I mean, you mentioned that he was repeatedly making threats and agitated. You know, we have heard outside during this news conference from the attorney for the family, who said basically for approximately 2 hours and 20 minutes, he was asking for help, but wasn't evaluated until the paramedics got there. He never got any medical attention until just before his heart stopped. Can you comment on that?
Well, you know, you can see that from the video that, you know, one could interpret what happened here as a cry for help. I mean, this is what we are dealing with. We're dealing with people with mental health, with drug addiction, other issues, and there's almost nowhere to go for help. The police seem to be the place where people go for help, but it's hard to interpret the entirety of the video as that he's asking for help. Something is going on. He's reporting that he has a warrant, that he has drugs, that he wants to kill people, but there isn't something clear that he's asking for help from the police.
Should they have called the PERT team?
You know, these are issues in my other hat as the public safety official in the county that I'm looking at. What procedures, what things. This is different than assessing criminal liability, but looking at the whole system of what can we do better, where we're not just looking at the prosecution, because at that point it's too late. We're looking at the prevention of better systems to protect people who suffer from mental illness and from addiction and a deadly combination like this. There is some information that the PERT team is not often called when there are threats of violence, that they don't really call them for that sort of scenario because they could almost be in the way where the police has to protect another person or look out for another person. But I do think that in my role as public safety leader, I've been working very hard at looking really around the country at systems that deal with crisis intervention, mental health care, that are working. We are studying them very closely. We're looking at best practices. You know, we have to do better. We have to continue to do better, and it is one of my priorities to do so.
Can you clarify the legal definition of homicide? Because it's been determined homicide by the medical examiner, and I thought you said it's the hands of another person. So in this case, who is the other person?
It refers to the police and the deputy sheriffs. That's the hands of another that the coroner refers to. So, for example, with the medical professionals, people die all the time in the care of a doctor, or in this case, in the care of paramedics. That's when his heart really stopped. But there's almost an exception under the law for doctors, and what the coroners tell us is because people sort of sign a waiver to be under the care of a doctor, so if they die on the operating table, or they don't consider it, they don't label it a homicide as under the hands of another. So what the coroner writes is his death was in part at the hands of another, therefore the manner of death is listed as homicide. And he does in his report say very clearly that the methamphetamine alone could have killed them, that the toxicity from the methamphetamine and the agitated state it caused for that much time could have killed them, but still, because the hands of another were involved, and involved in ways that could impact the respiratory system. What the doctors tell us is they have to check a box, and that's the box that they check. So even in an officer-involved shooting where somebody has a gun to the head of a hostage and a police officer shoots that person, that's labeled a homicide, even though by common sense interpretation, it's not going to be legally a criminal act. And the coroner does add that although it's unintentional, he has to label it a homicide, even if there's no intent or intent to harm by the officers. So there's a different, completely, it is difficult, but it's what we see. If you look back at other cases of in custody, that's just in the last couple of years, you'll see the same labeling by the coroner for very similar circumstances. His checkbox is completely different than what the California state law says about what a murder is.
Now, did respiratory failure come first or the cardiac arrest?
The coroner says that he cannot tell us that.
And at what point was the shirt pulled over his head?
That happened, I know it's hard to see on the video, in the Sally Port towards the end of the video, the incident. Right after you see a deputy walk away, that's the deputy that was spit on, and that Mr. McNeil said, "I got you, F-U-C-K-E-R." It's after that the deputy pulls Mr. McNeil's, not that deputy, but a different deputy pulls Mr. McNeil's T-shirt up, his own T-shirt up. Mr. McNeil bites it, so it actually doesn't go all the way up. And you can see it kind of held a little bit away from the face when you look at the video closely, but you have to look at it as many times as we did.
And since you looked at it so much, can you give some more insight on what was happening after they pulled him out of the car and he was in the Sally Port? There's no audio at that point.
Yeah.
And it's difficult to see with so many officers around him. What was happening in that huddle?
So what we're told, and it's a little bit consistent, is that it continued similar to what you actually hear at the very beginning. You could hear it faintly because of the National City Police officer still having his body worn. The same talk, the same Mr. McNeil talking about spitting, talking about killing, talking. You can kind of hear his voice, and we're told it continues in the same manner.
But at that point, there was nothing to suggest that he was in any kind of medical distress, in your opinion?
No, but we have to be clear that when the nurse saw Mr. McNeil, she did find that his, that's why they called the ambulance, his temperature was 100 degrees, and that he had an elevated pulse of 120. But she didn't believe it was the kind of stress that was deadly at the moment. She didn't think he was having an overdose at that moment.
And so is that the reason why he was never actually booked or taken into custody by the sheriff's department?
Correct. The nurse, in consultation with the sheriff's staff, decided that he needed an ambulance and he needed to be taken. And we understand it's a combination of his suicidal ideation and also his heightened temperature.
So we don't know then if his temperature and pulse were heightened prior to the nurse checking him out. Theoretically, or is it possible that could have had those readings while he was being transported?
We don't know, and it's obviously possible. That heart rate and that temperature is not something we don't see. It's not off the chart. It's also often related to meth toxicity. So it would not be surprising if he had had that temperature for a while. But what the nurse notes is he continued to talk with her. He continued to respond and speak. So she didn't have that drastic concern that it's a life-threatening issue at that moment.
When the officers had him in
I don't know of anything that says they're legally obligated to do that. You see often in struggles with police that you'll see some superficial injuries, other injuries. We haven't seen police immediately seek medical care for those. We do see them seek medical care if there was something really serious that happens medically to someone.
But now, Summer, is it that you don't know, or is it just no?
Which one? I'm sorry.
If they were obligated to give him medical attention after he sustained that injury to his mouth?
Okay, so I don't know for sure, but I know for the time that I've seen and reviewed multiple cases that that doesn't happen. That if there's a minor injury in a struggle, police is chasing somebody, they fall down, they don't take them for medical care. There's a certain point before they take them for medical care.
That speaks to policy, though. I mean, as yourself, you mentioned that you're the public safety official, or under this context, when do you provide that feedback to the law enforcement agencies to say that this maybe should be a policy or make them policy recommendations?
And I don't know whether I would make this policy recommendation on a tooth issue or something like that, but I can tell you that this is a work in progress. This is just like we were able to amend the body-worn camera protocol, working on protocols, working on prevention, protection, policing that is at the highest training level for crisis intervention. That's a priority for me, and you're going to be seeing, I've asked for now a comprehensive 25-year study for all officer-involved shootings that I'm going to be reviewing patterns, commonalities, things that we can learn and do better in the future.
I know this has been a very difficult day for you. Can you tell us what the family's reaction was when you informed them that there would be no criminal liability against any of the officers involved?
They were extremely wonderful people, extremely respectful, listened to everything I had to say. I'm sure it was not the news they wanted to hear. I, explained to them that I don't determine in this context, I don't determine if things could have been done better, if those are things, and I told the family I would love to, after this whole case is over and whatever path they go down, if they have other avenues that they want to pursue, that I would love to sit down and talk with them, because as a family with someone who they lost this way, and also someone who suffered from mental health issues and addiction, what can we do better? There's things they can teach us, and I would love to sit down and work with them along with other families on this issue.
Did they have a reaction specifically, however, to the fact that you're not pursuing criminal charges?
No, they just listened, and I shook each one of their hands. They shook my hand. They thanked me for coming in. They thought it was unusual, that they didn't expect that I would come in personally, but it was a very difficult time, but I was very impressed with their poise and their level of respect and their level of listening.
Two questions on the kind of the criminal justice piece here relating to him. Was he an informant or provide information on any other cases besides Dr. J's?
Yes.
How many and when, do you know?
He was a victim in his own case, and he provided information but never testified. It didn't go that far on 2 other cases.
And were those, can you describe those homicide cases, were they gang cases, was he a jail justice?
I can't describe it.
And was that recently, do you know, or before or after the Dr. J show?
I don't know the answer to that.
And why do you know why he went to National City Police Department? Was it because that was where the September arrest, they were the arresting agency, I would think, in the September DUI arrest, and the warrant that he refers to, was that the warrant that they kicked out 4 days earlier by the court?
I'm thinking it is that warrant, but I don't know for sure. I think he was nearby. He was staying nearby at the time, but I can't be sure. I might have to get back to you on this. I know that someone reported that he had left. He was gone early that morning. I don't know why he picked National City PD.
Real quick. He was in the wrap a lot. Are there guidelines or protocols or limits to how long one should be in one of those? He was in it, then he stayed out, then he was back in it. He was in the car for an hour in the wrap. I mean, I know it's designed
Yes.
not to be restrictive, but
Right.
there's a limit to every use of evidence.
I don't know the specific time limit that you're supposed to be in it. I do know that the coroner asked to be put in the wrap and wanted to experience what that would be like and what sort of pressure that would be, and that he seemed comfortable with the wrap, that its intended purpose to actually not put pressure on you because most of the time you're sitting up in it, that the intended purpose sounded like it was something that was good.
Do you know that the corner where the spits out to?
No, but he knew which spit socks they are. No, he didn't wear it at the same time.
They didn't have both on at the same
No, I don't believe so.
So will you have any recommended policy changes or ideas in terms of the use of restraints, given this?
You know, I don't have any specific recommendations at this moment, but like I said, it is a priority for me, and you're going to see some specific things being put out once we've fully studied them and vetted them. And like the protocol, you didn't hear from me, although I was working diligently on it until we had it confirmed, because one of the things that's very important to move things forward is to establish collaboration, to make sure that everyone is rowing in the same direction and that the policy is supported, because policies that aren't supported don't get very far.
And one last question for me. This has obviously been a very high-profile case among protesters and people down in National City. What do you say to their concerns about the transparency of this whole process?
Right. Well, I welcome First Amendment and people talking and having concerns. I know some of the individuals actually had worked with them in the past on restorative justice and other things. You know, the one thing that I just tell you frankly, that the one thing that worried me, not everything they did and said and all of that, that's people's right to protest, and that I welcome it. What was worrisome is the things that the family was being told that are just not true. The things that if you heard your loved one was kicked and beaten, his teeth knocked out, and their spine is dislocated and all of that. I mean, that I can't imagine, on top of the loss, that you now are imagining this additional pain that your loved one went through. So I would just say to everybody, know that I'm going to be for providing as much information as I can. I am for as much sharing within the rules of privacy and other considerations. Take time to wait for the real evidence to come out and judge it for yourself. And I welcome this group to continue to ask the questions, and hopefully I'll earn their trust that I'm going to give them the answers. It might not be at that very moment, because I don't want to guess at it. I want to do a good, objective, thorough job.
Clearly, from the video, it seems that the police officers involved were not necessarily violent towards him, and you were not able to prove that they had some intent to cause harm. But just theoretically, say all of this happened in 1 hour, I still think the family would be angry and demanding answers why he was So I think what we're trying to get at is, what is the threshold? If this took 3 hours, or if the police officer left him in a patrol car for 4 hours or something, at what point does a decision like that become the reason for his death? Does that make sense?
Yes, when the medical science and the evidence proves beyond a reasonable doubt that that was the reason he died, and that it's a substantial factor, and that also that the officers acted with the intent required. We have different systems. We have the criminal justice system. It has a different path, different requirements. And that's why I'm saying that's different than the role of prevention and protection that I also take very seriously. That's a different role that I have. But when I'm judging criminal behavior, I have to judge it based on the facts and the evidence. And it doesn't work that way. There isn't anything that says, you know, after 3 hours you get criminally charged. There just isn't anything like that.
No, but I'm saying clearly time was an issue here. Saving, if he had gotten to the hospital quicker, potentially medical care could have saved him.
I don't think we can even say that. Like I said, over 300 people died of just methamphetamine overdose in 2017. So we can't.
This wasn't treated as an overdose. It was treated as a criminal act, right? If it was treated as an overdose, he would have been sent straight to the hospital, right?
What I'm saying to you is that we can't say whether he would have been saved at what point. I'd be guessing, and that's not my job. Thank you very much, everybody.